Hello and welcome. We're discussing 40 years of the Surrogacy Arrangements Act. What next for surrogacy? This panel discussion is taking place thanks to the generous support of the British Fertility Society and Cooper Surgical. This discussion is to mark the fact that it's 40 years since the UK introduced dedicated legislation to govern surrogacy. It was the 16th of July 1985 that the Surrogacy Arrangements Act received royal assent. So we're actually on the right day. And it seems funny that it was just a few days after that very, very famous Live Aid concert took place, which has been the subject of global news coverage again to mark its 40th anniversary over the weekend, I noticed. I don't know about you, but those of you who are around in 1985, I have to say I was much more interested in the Live Aid concert than I was in surrogacy. But that's probably changed over the years. Over the years, surrogacy has changed. It has been slowly increasing as a way of having a family. And in 2018, the Department of Health and Social Care issued guidance for couples considering surrogacy for the very first time. And two sets of guidelines were issued, one for surrogates and intended parents, and the other for healthcare professionals who were working with them. Now, since it's not that nothing has happened apart from that guidance since 1985, but the law has been updated in a rather piecemeal fashion, I think it's fair to say. And this has led to some of the most senior family court judges, together with surrogacy organisations, academics, surrogates, intended parents, all calling for surrogacy law to be updated. And so the Law Commission of England and Wales and the Scottish Law Commission took up that work and published their joint report, Building Families Through Surrogacy, a New Law. They published that in March 2023 together with a draft bill. What happens to that bill remains to be seen, and I think that's something we'll be discussing tonight. Now, the PET team have been looking through our extensive BioNews archive and have created a series of articles for you to read on surrogacy over the time that we've been publishing in our new In Focus section of the website. And the Surrogacy in Focus page has been kindly supported by the law firm Brabner's. And if you take a look at it, you'll find that as far back as 1999, the first year that BioNews was published, we were covering cases that involved surrogacy. And then a woman who'd been a victim of medical negligence was seeking damages to fund a surrogacy arrangement. And many of the articles in this Surrogacy in Focus have been written by some of tonight's panelists. And on the panel, we have a great range of expertise and experience for you. And PET is delighted to bring you two surrogates, a parent via surrogacy, and legal scholars and practitioners whose work includes a project that seeks the views of children whose lives have in some way been touched by surrogacy. So it gives me great pleasure now to introduce our first speaker this evening, and that is Kim Cotton. Kim is the first surrogate to come to public attention in the UK, and it was her circumstances that prompted the passing of the Surrogacy Arrangements Act in 1985. And Kim was then the founder of Childlessness Overcome Through Surrogacy, COTS, which was the UK's first surrogacy organisation.
I first encountered the term surrogacy back in 1983, which is 42 years ago now, during a segment on breakfast television. The discussion revolved around a commercial surrogate agency from the United States seeking to establish a parallel enterprise in the UK, actively recruiting women to serve as surrogates for childless couples. I found myself captivated by the entire concept. That evening, a panorama programme aired, providing a more comprehensive examination of the surrogacy process. I watched with keen interest alongside my husband and my mother, who happened to be visiting that night. I became enthralled by the notion, believing it would perfectly suit my circumstances. We had recently bought a substantial Victorian house in Finchley in complete need of renovation, a project that was proving to be quite overwhelming. The financial burden exceeded our initial expectations. We were living amidst chaos with 2 young children. The £6,500 fee would significantly alleviate our situation, and it was a task I could undertake from the comfort of my own home. Having experienced 2 uncomplicated pregnancies, I felt well equipped for the task. Both Jeff and myself and my mother were supportive. I managed to get the agency's address from the BBC and submitted my application to the United States without delay. It took nearly a year before any progress materialised. By that time, our family's financial circumstances had improved, rendering us less desperate. However, I could not shake off the persistent desire to help. I've always possessed a strong maternal instinct. Having met my husband when I was 15, we purchased our first home at 18, married at 19, and welcomed our first child, a boy, when I was 20, followed by a daughter 4 years later. Jeff had even undergone a vasectomy. Reflecting our certainty, we did not wish to expand our family further. Personally, I could not contemplate a life devoid of children. They are my entire world. I took my fertility for granted, having encountered no difficulties in conceiving, carrying, or giving birth. In those days, only traditional surrogacy was available, and with that particular agency, the process was conducted anonymously, preventing me from ever meeting the couple for whom I carried a child. I must admit this notion is now profoundly abhorrent to me, but I accepted it at the time. A health visitor acted as an intermediary, delivering fresh sperm samples from the biological father from my inseminations twice monthly. Remarkably, I conceived on the 2nd attempt. On the 4th of January 1985, I gave birth to baby Cotton amidst a media frenzy. I was entirely unaware that surrogacy would provoke such a controversy. While in labour, I was subjected to intense questioning by social services, who sought to ascertain the whereabouts of the baby's intended parents. Regrettably, I could not provide them with an answer. So consequently, unbeknownst to me, she became a ward of court the moment she was born. What ensued was a harrowing ordeal. I was compelled to leave the hospital without the baby. The hospital was besieged by cameras and reporters, forcing me to exit by being concealed beneath a blanket on the floor of a car, whisked away at breakneck speed. The agency abandoned the couple to contest for custody in the High Court, incurring an eye-watering £30,000 in legal fees. After 5 days, the judge granted them custody so they could return home abroad. The experience was profoundly traumatic for both them and me. I never experienced the elation I should have. Instead, I felt a deep sense of betrayal, especially from the agency. The uproar surrounding baby Cotton's birth shocked me to my very core. Headlines proclaimed "born to be sold" and "baby for sale," among other sensational phrases. Such narratives were deeply hurtful, particularly when I had always perceived my actions as inherently special. It is a shocking experience to find oneself thrust into the limelight, compelled to defend my actions on live television news broadcasts. I also felt a profound reluctance to leave my home after the journalists had had departed. I was frightened. However, I can honestly say that I never once encountered any overt hostility in person. Hostility, thankfully, was confined to talk show studios. Undoubtedly, the entire experience changed me. I had evolved from a timid mouse into a formidable lion, brimming with newfound confidence. Surrogacy became my profound passion, serving as my motivating life's work to empower others to tread the same path. Dame Mary Warnock, who was already overseeing a review of embryo research, expanded her mandate to encompass surrogacy, leading to the expedited passage of legislation in June 1985, just 6 months after baby Cotton was born. that prohibited commercial surrogacy and the solicitation of surrogates within the United Kingdom. I was not upset with that outcome, as I genuinely believed that the commercialization of surrogacy was inherently flawed. By this time, I found myself inundated with correspondence from infertile couples and prospective surrogates imploring me for my assistance. Initially, my involvement was modest, merely facilitating introductions between parties and hoping for a favourable resolution. In 1988, I co-founded COTS with the financial support of an intended father who had witnessed my interview on Wogan. We launched fittingly on Mother's Day in London with a press conference. This initiative allowed me to formalise the efforts I had already been undertaking. It is difficult to comprehend the extent of criticism I had once again to endure from the media. However, once we truly embarked on our endeavour, the number of successful journeys we orchestrated, resulting in the birth of surrogate infants, increased year after year. In 1991, I welcomed a set of twins through the process of gestational surrogacy. This time, the establishment were involved as IVF was required, a relatively new concept for surrogacy. The experience was somewhat daunting, as I feared I would once again be subjected to criticism. However, due to my altruistic efforts in assisting friends I had encountered through COTS, the absence of any commercial motivations, I was celebrated as a paragon of virtue. During my baby cotton pregnancy, I had felt profoundly isolated and lonely. However, the experience the second time around illuminated just how much I'd missed by not knowing the couple to whom I had entrusted my child. Linda participated in all my appointments. We shared everything, as she was actively engaged throughout the pregnancy. It was a truly remarkable experience. Linda and her husband, Robin, both attended the birth, which was a meticulously planned C-section accompanied by an epidural. The operating theatre was suffused with love and joyful tears as both babies, a boy and a girl, were safely delivered. Up until that juncture, all surrogate infants were born through traditional surrogacy, wherein the surrogate served as both the birth and the genetic mother. The advent of gestational surrogacy at a select number of clinics revolutionized this. Presently, an impressive 98% of all surrogate births are gestational, a development that significantly aids the surrogate in emotionally relinquishing the infant to their genetic parents. It resembles a form of extreme babysitting. By showcasing the successfulness of gestational surrogacy, an increasing number of clinics began to offer surrogacy as a standard procedure following the failure of all other treatments. Several years ago, I had the privilege of meeting Dame Mary Warnock, who candidly acknowledged that she had inadvertently inflicted a grave disservice upon the surrogacy community by prohibiting the advertisement for surrogates. She had been influenced by what she mistakenly perceived as public sentiment, which was in reality merely sensationalist media coverage. The advent of same-sex males being permitted to obtain a parental order has precipitated an overnight doubling of the demand for surrogate mothers. The dilemma, however, lies in the fact that while demand has surged, surrogacy has remained static. The supply has remained static. I have dedicated years to advocating for reforms concerning surrogacy laws, which in contemporary society are antiquated and irrelevant. It is imperative that we will be allowed to advertise for surrogates. Intending parents are subjected to protracted waiting periods, often lasting several months, to secure a parental order. During this interval, surrogates are understandably reluctant to still have legal responsibility for the child. We require a pre-parental order framework. Additionally, married surrogates do not wish to include their husbands' names on the birth certificate. Furthermore, it is essential that the issue of expenses be addressed comprehensively, yet capped at a reasonable threshold. Currently, surrogates receive compensation averaging between 15 and 20,000. IVF clinics represent a lucrative enterprise, adept at imposing significant charges. Pharmaceutical companies operate as a business, as do surrogacy lawyers and counsellors. Each of these entities reaps substantial financial rewards, while the surrogate, who undertakes the majority of the labour and bears the associated risks, must justify her expenses and meticulously account for every penny. This situation is profoundly unjust. It sickens me. Regrettably, COTS is set to close its doors in September of this year, largely due to the lack of available surrogates and the mounting pressure I feel in attempting to source them. To date, we have facilitated 1,142 births and currently have 5 ongoing pregnancies. I remain committed to guiding all our surrogates and intending parents through to their successful conclusion. It has been an honour to collaborate with such remarkable individuals. I found it impossible to totally turn my back on such an emotive issue, particularly as an increasing number of individuals are seeking surrogacy as a means to obtain parenthood. This prompted the suggestion that I establish a surrogacy consultancy advice line, which is already operational. Unfortunately, infertility knows no boundaries. It affects people from all walks of life. At least thanks to our pioneering efforts through COTS, surrogacy is now fully established in the UK as an alternative solution to childlessness.
We're going to move on now to our next speaker, Sarah Jones. And Sarah is from another surrogacy agency, Surrogacy UK, where Sarah is the chief executive. And Sarah has been a surrogate multiple times, 5 times, and she is in touch with all the families that she has helped to create. And for those of you who aren't aware, Surrogacy UK is a not-for-profit organisation that helps to create families through surrogacy and that champions ethical surrogacy.
So, as Sarah said, yes, my name's Sarah Jones. I have been a non-commercial surrogate 5 times over the last 20 years with Surrogacy UK. And every one of those journeys has happened under the current UK legal system, which hasn't really changed dramatically since 1985. Now, the other panellists that are going to speak later on can give expert information on surrogacy law. So I thought I would talk about how the law impacts me and my fellow surrogates. Now, as I said, I've carried 5 babies who are now between the ages of 21 and 5, nearly 5. But I never felt that they were mine. But legally, I was fully responsible for them for a period of time until their parents' parental order was granted. And it's only really through the trust and friendship that I shared with those intended parents that everything worked as it should. But the truth is, while trust is a beautiful and really necessary part of a surrogacy journey, it shouldn't have been the only safeguard that I had. I was very lucky that 23 years ago, I found an organisation, I found Surrogacy UK, that prioritised my welfare, that respected my autonomy and made sure I had enough information throughout the process. But I know that I'm very lucky that I had that. And I know that there are others within the surrogacy community that haven't had that experience. I don't live in a surrogacy bubble where all UK surrogacy is perfect. It does need safeguards, especially as it grows. Certainly 23 years ago, surrogacy conferences were a handful of people, and now they're like 600-700 people. The Surrogacy UK community has about 2,000 members. So, surrogacy is growing, and as it grows, it does need safeguards. This is why reform matters, because no surrogate should have to rely on luck or goodwill to be safe, informed, and respected through the process. Now, the new legal pathway that's being proposed would allow the intended parents to be recognised as the legal parents at birth. Now, this draws lots of attention from lots of people, especially some anti-surrogacy voices. They tend to focus on this part of the legal reform, so I'm going to address it. Now, the anti-surrogacy voices that are reporting somehow thinks that this means that surrogates are going to lose their voices, lose their autonomy, and importantly, lose their chance to change their mind should they want to. Certainly, I haven't known of any surrogates that have wanted to change their mind at all in the last 23 years. I have known of some cases in the independent world, so I do know that it can happen, although very, very minimal. Now, if you read through the full proposal for the legal reform, you will see that parents will only be recognised as the legal parents at birth with the surrogate's full and informed and ongoing consent, and that is really key for me. And she will only be able to do that if she has gone through a regulated process, so gone through a regulated surrogacy organisation who have mandated safeguards in place. So I think that this offers surrogates more chances to withdraw their consent and much more safeguarding, which is obviously a good thing. It can't be a bad thing. And the way I mean that it gives surrogates more chance to withdraw consent is that at the moment, when a parental order is granted, I'm able to give consent once. I'm able to say yes or no one time, sign my name, and that's it. Now, with the legal reform, I am able to give ongoing consent or indeed withdraw that consent at any point. So I think that's really important and really a positive change. But more importantly, it's what UK surrogates have asked for. So if you're fighting for the rights of surrogates, it's pretty key to understand what surrogates want and why they want it. As you can tell, I'm not a massive fan of big surrogate saviours, as I like to call them, especially when they have no experience of surrogacy at all, or indeed haven't even spoken to a surrogate. I would sort of invite anybody who wants to fight for our rights to please have a conversation with us first. Also, people should look at these proposals in full, not just read a headline. Like I've seen lots of things on Twitter that are really taken out of context and no good information came from a tweet. That's what I would say. Surrogacy is much more complicated than that. And people should read the legal reforms in its entirety to really understand it. It is a lengthy document. I'm not saying it's not, but it's definitely a good idea to do that. Also, the proposed law includes things like mandatory counselling and independent legal advice. Like these are things that I think every surrogate should have anyway. We do offer that at Surrogacy UK, but also Surrogacy UK is only a part of the surrogacy community. There should be stronger, the proposed law also proposes stronger screening and safeguarding for everyone involved. Certainly at Surrogacy UK, we have hundreds of surrogate applications that come through. Anywhere from between 400 to 600 surrogate applications a year. That is an enormous amount of people that are volunteering to be surrogates. Now, we at Surrogacy UK probably only allow about 13% of those applications to go through. So that's an awful lot of people that are still wanting to be surrogates that go somewhere. So these mandatory screening and safeguarding proposals have got to be a good thing for all potential surrogates, even if it means that they can't be surrogates. These aren't threats to our autonomy in any way. These are protections that we should have had all along. As I say, I realise that I'm very lucky that I found an organisation that offered me these things. Now, it is important when we talk about UK surrogacy that we recognise what that looks like in reality, because we need laws that reflect the reality of UK surrogacy. And I am aware that UK surrogacy is very much different from any other types of surrogacy that happens overseas, and the two should not be conflated at all. Now, the reality of my last journey was that I was a 40-year-old woman making an informed decision to help my long-standing friends to complete their family. This was not a rushed decision. We spent 2 years trying to conceive through IVF. It was a real testament to our teamwork and our relationship that we conceived. And that little boy is now 5 years old. He lives with his parents, his genetic mum and his genetic dad, with his full genetic brothers. It's a family full of boys. And he is in the family that he was always meant to be a part of. That's his life and his story. Now, I go and spend time there. I go out with his mum and dad. I spend the night there. I get up in the morning. I get up earlier than his mum and dad. And while the boys, only one of whom I carried, make my breakfast for me, they show me how to use their fancy kettle that I can never figure out how to work. They rabbit on about what they're doing in school, and they will show me where the youngest, who I did carry, where he smashed the patio door with an epic cricket ball swing. You know, that's the reality of my life as a surrogate. I am involved in their life. They know who I am, what I did, and I have a valuable place in their family. It's not anything strange to them. It's not anything strange to me or my family. It's just a different type of family. And I think that's the reality for a lot of surrogacy teams in the UK. And this is the truth. And this is what I feel very, very strongly, that just because I gave birth to him, I don't think I should have the legal right to veto that child's right to be raised in his own family. I don't think that's in his best interests. He is exactly where he should be. He is the missing puzzle piece of that family. And I'm very happy to be a part of that extended family. The idea that the person who gave birth should automatically hold this lifelong power over a child's legal status is not protective. I think it's very harmful. Children aren't anyone's possession, not even mine if I gave birth to them. And this should be reflected in surrogacy law. It should always be what's in the best interest of the child. Now, current surrogacy law might not change in the near future. You know, certainly we've been campaigning for legal change for the last 11 or 12 years. We know it's not going to happen quickly, but it will continue in its current form. We will still continue to have surrogacy arrangements happening and us navigating the current laws as we have done for the last 30 years. But with surrogacy growing, we do need to recognise that it needs to change. Quite scarily, I've seen a huge rise recently in the last 3 months or so in overseas surrogacy agencies targeting UK intended parents, offering guaranteed babies at any cost, and more scarily, advertising plans to ship surrogates to the UK or indeed anywhere else to give birth. I've personally reported every case that I've seen. Like, this is terrible. This is scary. But the truth is, unless the law changes here, we are going to see more of this. Surrogacy isn't going to disappear. It will just go somewhere where there are unethical practices. Because when the UK doesn't offer a safe, ethical and transparent surrogacy framework, people will look elsewhere, and that opens that door to exploitation. I am very openly against international surrogacy and commercial surrogacy, and always have been. I worry deeply about women that will be harmed during that process, because those arrangements that happen where women are shipped to other countries to give birth, they do not care about that surrogate's protection or their autonomy, and they're all about profit. So if we do want to protect surrogates, and we really want to protect surrogates, we need to stop pretending that standing still is safer than moving forward. And that's the future we should be aiming for. Thank you.
Thank you very much, Sarah, for that rally cry of how to protect surrogates. And if you want to know what surrogates think, ask them. Thank you for that. So our next speaker this evening is Paul Morgan-Bentley. Paul is a parent via surrogacy. He's head of investigations at the Times and author of the book The Equal Parent: How Sharing the Load Helps the Whole Family Thrive. And he's an award-winning journalist, I should say. He's a recipient of the Hugh Cudlip Award for Campaigning Journalism, and also the Future of Media Award, which he was given by the Press Gazette.
Yes, I am a father through surrogacy. I have a 5-year-old son called Solly. who is the center of mine and my husband's lives. And we have another one on the way. We're expecting another boy through surrogacy at the end of August with Rachel, Rachel Pegg, who we met through Surrogacy UK. I think, as Sarah said, there are some other speakers that will talk that are kind of legal experts, and hopefully I can give just an insight into the reality of what I have experienced as a dad through surrogacy and going through the process before we had Solly. I should say that actually, before we had our son, before we started this journey, I was initially quite skeptical about surrogacy. I was worried about it. And I'd have these discussions with my husband. We both knew from very early on that we both wanted kids. Can't actually remember ever discussing it with him when we first met, but we must have discussed it very early because I never remember not knowing that about Robin as well, that he wanted potentially to have a child somehow. That was important to us if possible. But I was worried about those things that kind of lots of people I think worry about. Firstly, whether it was the best thing for a child to be born through surrogacy, and also whether the women who were surrogates genuinely wanted to do it, or were they being exploited? And, I had questions about that, and I can kind of picture myself on a tube platform on the way to work on my phone, zooming in to these kind of Cambridge University studies about the outcomes for children born through surrogacy, and being just massively convinced by the outcomes. It was, research by the top university in the world looking at long-term outcomes for children born to all types of non-traditional families. And it was really, really reassuring. And that definitely reassured me. And it's why it's amazing that a couple of the other panelists here are doing that work, researching the voices of children that are involved in surrogacy. I find that so exciting because so many people speak for these children like my son. And actually, we should all listen a bit more rather than assuming what people think. And that's something I learned also about surrogates. When my husband and I went to a Surrogacy UK event, must have been, I think, 2017. 2018, I think, for the first time. And I just tried to be open-minded, and I thought, well, let's meet some people in the community and find out what they're like. And often Sarah mentioned Twitter and opposing voices to surrogacy, and I think often people can make assumptions about surrogates. And I kind of what I tend to do, I used to be more active than I am now on Twitter, but when people were raising those kind of concerns, I used to quite often just at all the surrogates that I knew who were on Twitter and just say, well, let's ask, but it's interesting how quickly people then switch off from the conversation because they've come to their conclusions about what surrogates must think, and they don't actually want to hear from them. And I just so quickly, after meeting Surrogacy UK surrogates, it was so clear that the women that I had met were doing it for their own reasons, complex human reasons, whatever they were. And there absolutely didn't seem to be coercion there. And any concerns I had before really did fly away so quickly. We know that we're lucky in lots of ways and have had an amazing experience with Surrogacy UK. We went through gestational surrogacy with an anonymous egg donor. But obviously, Solly and the new baby hopefully will, when they're older, will be able to find out identifying information about her, and we would totally support that. And frankly, I'd love to meet her and give her a massive cuddle and say thank you for all she's done for us. And then through Surrogacy UK, we met Rachel, who had independently joined the organisation looking to become a surrogate. And just very similar to Sarah, that's our relationship with her. She call her what you like, a surrogate mother, Auntie Rachel. She's a hugely significant person in our life. I think at the moment for our 5-year-old son, he's really keen on her in the way that he is loads of other kind of our friends, and he loves her in some way, but she's Auntie Rachel to him. She's in our lives. Her family's in our lives. At the moment, at his age, I think he's probably more interested in her 2 sons, who he runs around after, and are like kind of cousin figures. And he is, he loves them and looks up to them. But we see them a few times a year. We're, at the moment, with her being pregnant, we're seeing each other every week or so with all the kind of appointments and stuff like that. But they're just, a huge part of our life, and it's worked out brilliantly for us. The law, when we had Solly, I think I'd have assumed naively if we had another child 5 years later that things might have changed. And clearly they haven't in that time. And, it is entirely based on trust at the moment. And I absolutely share what Sarah says. It makes no sense to me that all the checks to do with welfare and consent happen post-birth, but anyone through traditional surrogacy, let's say, could try to get pregnant and have a surrogate pregnancy without there being any encouragement for checks, for independent legal advice, for counselling. We went through some of that because if you go through gestational surrogacy, you have to through clinics, but frankly, it felt more like a tick box exercise. We had the support of Surrogacy UK, and that really reassured us because we knew that they were doing checks on intended parents and on potential surrogates, and we're in touch with doctors and wellbeing checks and things like that. But I think the discussion around legal change, often at the moment, the voices that you hear the loudest focus on what is presented as a liberalizing of the law. And I just think that's such a misrepresentation because actually the concern at the moment should be that there aren't enough checks beforehand to ensure welfare. And actually these proposals do the new kind of proposed pathway does then mean that people are encouraged to explore surrogacy in the UK with all those checks before conception at the most important time, and then with the ongoing potential for surrogates to change their mind if they want to, etc., throughout the pregnancy and after birth. Yeah, and so that's my experience of being a father through surrogacy. The reality of having a child through surrogacy, I think having a child is a leveler. And actually, what we learned very quickly is that it didn't matter if you were a man or woman, had a child through adoption or surrogacy, or through falling pregnant naturally or going through IVF treatment. You have a baby, and you're adults who just want to look after this child and do their best for this child. And it's partly why I wrote a book called The Equal Parent, which is it talks about our surrogacy journey, but actually it's more about the ongoing research about what having a baby does to people and the biological changes that happen to individuals when they become a parent, including dads, and how our brains change and how we respond to babies and all that potential for nurturing in different people. And about equality and how we focus so much on women at work, but neglect often this idea that men should be equal at home. So that kind of part of that experience and seeing how it was such a leveler with all my friends who are having children through other means inspired me writing the book.
So following on now from Paul, we have Professor Kirsty Horsey. And Kirsty is Professor of Law at Loughborough University, and she's an academic associate at 1GC Family Law. And she's a co-investigator at the Children's Voices in Surrogacy Law project. Previously, Kirsty was Professor of Law at the University of Kent and Senior Research Associate at London Women's Clinic. She's co-editor of the book Future Directions in Surrogacy Law and editor of the books Revisiting the Regulation of Human Fertilization and Embryology and Diverse Voices in Tort Law, and also the co-author of a couple of books on tort, so the Tort Law book and Case Law on Tort. But of course, Kirsty is best known to us here at PET as a long-standing editor of BioNews back in the day.
Been asked to share some perspectives from surrogacy research, which I have been doing since the late 90s. So some of the stuff I've said that I had here has already been covered for me, so I can skip over some of it nice and fast, I think, because I can thank Kim and Sarah and Paul for leading the way there. So I was just going to talk about some context of why I think law reform is needed and why now in particular, and then talk a little bit about some of the Law Commission's proposals and the draft surrogacy bill. And like we do have a surrogacy bill, and I'm a lawyer and I think bills are there to be debated, and so I'll come back to that point later. And I'm going to give some examples of and from, very briefly, some lived experience research, which I think is very important. So we all know the context. So this Act is 40 years old. It was passed very hastily in response to a bit of moral panic at the time and what the Warnock report had said and Kim's case. It has led to a fairly, what could be called tolerant environment for surrogacy in the UK, though it does criminalise some commercialised aspects of surrogacy, which has led to a particular sort of model of surrogacy being able to arise and flourish, as we've heard from some of the speakers already. My particular interest is legal parenthood, and that the law that governs that dates from 1990, the Human Fertilisation and Embryology Act, with some later amendments to that in the 2008 Act, and then another later amendment in 2018 when there was a remedial order allowing solo applicants to apply for a parental order. And all applicants for a parental order, which is the court order that transfers legal parenthood from the surrogate and often her spouse or partner to the intended parents, they have to meet certain criteria in order to be able to do that. And I think, I don't know, maybe Natalie will talk about some of those criteria or the growing irrelevance of some of those criteria. What research has shown, mine and from others, is that surrogacy law crucially does not align with the best interests of children and families created through surrogacy for many of the reasons that the speakers have already mentioned. Families have changed quite significantly since 1985 and 1990, and this was all recognised by the Law Commission in the project they did and is reflected in their recommendations from 2023 and the draft surrogacy bill. So I wanted to focus in on this pathway to parenthood, which has already been mentioned, but what it would do is, if it is followed, and that's an if, legal parenthood will be able to be achieved by the intended parents from birth. And as Sarah, I think, mentioned, that's really what surrogates want, or many surrogates want. It's obviously what intended parents would like to happen, but it also has benefits for children because the people who are caring for them also have legal responsibility for them and are able to make things like, medical decisions and that kind of thing. As has already been said, there's a lot of front loading in this pathway that, medical and criminal checks, welfare of the child assessments, informed consent, legal advice and counselling are all front loaded in order to be able to enter this pathway in the first place. And the pathway will be overseen by regulated non-profit surrogacy organisations known as RSOs, which will support the completion of surrogacy agreements known as regulated surrogacy agreements or RSAs. And this is proposed to be regulated by the HFEA, which has significant amounts of experience in regulating the fertility sector and is sort of world leading in that respect. The recommendations also propose that expenses that can be recompensed to surrogates would be more clearly defined. The way they have done this, some people have described as quite prohibitive or, maybe more inflexible than modes of good practice that have grown up organically over the last 40 years. But as Kim mentioned, RSOs will be able to advertise, which is a change. But some things stay the same. For example, at least one intended parent must have a genetic link to the child in order for this to be a pathway surrogacy. And as Sarah mentioned, the surrogate retains her right to withdraw her consent to the intended parents being legal parents, although this has a different effect both pre and post birth, but is an ongoing process. Crucially, also, details of the surrogacy arrangements will be entered on a new surrogacy register, which gives children the ability at some point in their lives to go and find out the circumstances of their birth, and that will operate alongside the donor conception register where appropriate. That detail has yet to be worked out because at the moment we are only at recommendations stage. But crucially, the other thing to remember is that if the pathway is not followed, and this whole sort of carrot and stick kind of thing, the intended parents will still need to apply for a parental order. So anyone who doesn't decide that they want to do it this way with all these safeguards built in pre-conception, or who go overseas, will need to apply for a parental order, although that process will be a bit more streamlined. So this is just a visual This is the Law Commission's own infographic, but it just visually shows everything above the line in the middle is preconception. So you can see that everything is front loaded in all the checks and balances and safeguards, crucially, that allow what tends to be a mode of good practice that already exists to just happen with the outcomes that everybody wants. And as you can see, the regulated surrogacy organisations have a significant role in that. There are still some other safeguards built in or built into the proposals. So there are eligibility conditions, minimum age limits for surrogates and intended parents. Where they are two intended parents, they must be in a kind of recognised relationship. And in relation to what Sarah was saying about sort of moving surrogates between jurisdictions and things, at least one of the intended parents and the surrogate must meet a test of connection with the UK, both at the time the pathway is entered, so after all those pre-conception checks, and when the baby is born. So that's yet another safeguard. And so this is what I want to say. So the study at the top here is the one that Paul mentioned that he was reading on the screens on his phone on the station. And it's, like a very famous study for those of us who have researched surrogacy. This is a longitudinal study by Professor Susan Gorenbach at Cambridge University. And it's followed families created by surrogacy from 2000 onwards, following children from infancy to adulthood. And it's found, gently, to sum it up in a couple of words, that the children are all right, the families are all right. And many of these other studies, and I apologise if I've missed anybody off here, because I was just trying to sort of cobble it together. I was thinking, people always say there's not enough research. And then I started putting these things down going, actually, there's quite a lot when you come to it. So a lot of these names on here are people who did work at the Cambridge Centre for Family Research, and there are other types of reports from surrogacy organisations. There are reports about why people might go overseas as opposed to staying at home. There are reports about how surrogates feel about the law. There's the study that's already been mentioned about children's voices, about how they feel about surrogacy. And there's all kinds of things out there. And there's more out there from other comparable jurisdictions too. So actually, when I came to think about it, there is a decent amount of lived experience research. And I think that is very important, particularly when you're talking about reforms. And so I wanted to talk in particular about research I did in 2022 with surrogates. So this was through one London clinic. Sarah mentioned that I worked at London Women's Clinic as a researcher for a while, and that gave me the privilege of being able to speak to, via survey and then later via interviews, surrogates who had been through that clinic to determine what they thought about what was at the time just the Law Commission's consultation proposals rather than the final proposals, but where this pathway was first outlined, that the intended parents would be able to become legal parents at birth instead of the surrogates. And 45 surrogates answered about this, and 39 of them were outright agreed with the proposal for this pathway. 4 said they chose they don't know option just because they didn't know enough about the proposals, and some of these surrogates had been surrogates quite a long time ago and were not engaged at all with surrogacy anymore. Only 2 said they didn't agree, but neither of these seemed to have disagreed in principle with the idea. One didn't like it because they didn't think that details of surrogacy arrangements should be on a national registry, and the other one disagreed because they thought it would just be a long and unnecessary process. 31 surrogates gave detailed reasons in free text for supporting the procedure, supporting the proposal for the pathway. And of those, 4 themes emerged, including, as you can see here, sort of pragmatism, best reflecting surrogates' own ambitions and understanding of what they were doing, enabling the intended parents to have rights and responsibilities from the outset, and better reflecting all participants, including babies' best interests. And I'll let you read some of these comments. These are some of the drawn out from the free text responses. I just wanted to highlight the one at the bottom here. This surrogate thought the pathway was brilliant, adding that it was the hardest bit when one of the nurses knocked and said, "Mum," and I said the mum was next door, and the nurse said, "Legally I was, but I know I gave birth and everything, but I'm not the mother." And I put a little asterisk there to remind me that actually that kind of questioning of the terminology in healthcare settings came up quite a lot, not necessarily in comments on the pathway, but quite a lot through the survey. There are a lot of people just saying, the language that people use isn't right. There's some more comments here. Some of them are quite long. There was one to draw your attention to at the bottom, not wanting to be the legal mother. The intended parents should be the parents. Even though my egg was used, I think I should be classed as an egg donor and a surrogate. So this is a surrogate who was involved in, what might be called a version of traditional surrogacy, although it was done through a clinic. So what next? So we know that these proposals are out there. We know the draft bill is out there. We also know there's all this lived experience research out there, and that, I think, it's time for the two of those things to come together. So obviously the proposals were made in 2023 when the government of the time was slightly chaotic, to describe it gently. But since then we've had a general election, we've got a new government, but what they have told the law commissions is that they can't prioritise surrogacy at the time. The Department of Health has other priorities. But they have said they will publish a government response as time allows and will look to consider the issue in the future. So that's kind of what I'm clinging on to, because meanwhile things are happening elsewhere. Ireland's already passed surrogacy legislation. New Zealand and Australia are currently looking at their surrogacy legislation. The Australian Law Reform Commission is looking at it like right now. And as people have mentioned or alluded to earlier, there are some scandals that are happening out there. There's some atrocious stories about surrogacy being done in wholly unethical and, terrible ways, which are exploitative of women and therefore not good for children or anybody else. And at the same time, I think Natalie's going to talk about some difficult cases that have been coming through the courts in the UK. And much of that, I think, could be avoidable if we modernised our law. And as Paul mentioned, I don't think it's a liberalisation, it's a tightening up of safeguards. And that's all important. This idea of debate is important because at the same time, there's strong-voiced minority opinions becoming increasingly loud. I think Sarah mentioned that as well. These are ideological in basis. They want to ban all surrogacy on the basis of some of the things that are happening elsewhere, which often get conflated. There's a tendency to convey misinformation, and I think this needs to be challenged. And this is where the lived experience research comes in, where you can have some facts and show the good side of surrogacy, what it looks like to do surrogacy ethically. And that's what needs to inform MPs and peers. But first, we need to get the bill before Parliament, because it's only by it being debated, and our Parliament has got a good history of this, is that it can, it's not necessarily perfect, the bill as it is presented, but that's what debate is for. Amendments can be made, amendments can be debated, etc. And at the same time, surrogacy support organisations who are doing an amazing job already need to become regulation ready. So that's my thing. Debate needs to happen. It's all about the safeguarding, but debate needs to be informed by lived experience.
So we'll move on now to our next speaker, Natalie Sutherland. Natalie is a partner, fertility officer, and leader of the Modern Families Department at Burgess Me Family Law. Natalie is also a trustee of PET, and she is co-chair of Resolution's Children Committee, and she is the host of the Infertility in the City podcast. Natalie is a contributor to books, including No One Talks About This Stuff, 22 Stories of Almost Parenthood.
So I've got 10 minutes to talk to you about surrogacy cases that we've been seeing through the High Court. In the last sort of 18 months, we've actually been inundated actually with cases in the last 12-18 months. Normally the cases that the surrogates that we've heard from today, straightforward cases, don't get reported. I was in the High Court today with clients. US surrogacy not going to be reported. It was straightforward and no problems. But the cases that we see are reported are the ones where there are issues, and many people do go abroad, as Kirsty said, because of issues with this jurisdiction, but they're not necessarily going to safe jurisdictions. And there are also bad actors working in this space that are perhaps recommending jurisdictions where they shouldn't be, essentially. So what type of cases are we seeing? So we're seeing multiple jurisdictions being involved with travelling surrogates, anonymous surrogates, which is really, really worrying. We're seeing older intended parents where the spotlight is on them. So we're dealing with welfare issues. Babies being born in jurisdictions that do not permit surrogacy for the relationship type. So where couples are going to, like gay couples are going where gay surrogacy for gay people is not allowed. The birth is often moved by the agencies, and I'm going to talk about some of those cases. And sadly, where we've seen cases where there's been a death of an intended parent, where a surrogate has actually been incapacitated through the giving birth, and where if double donation is used, you can't use a parental order, so you have to use adoption. And there's been a recent case about that as well. So I'm not going to be able to talk about all of them. I'm just going to deal with the top two. So that's the travelling surrogates involving multiple jurisdictions and anonymous surrogates. So the first case is Z Foreign Surrogacy 2024. This is a Mrs. Justice Tice case from October 2024. This is a same-sex male couple who are in a civil partnership. So they're named A and B in the judgment, and they're from countries where homosexuality is illegal. But they entered into a surrogacy arrangement with an agency based in country Y. We're not told the name of the country, so it's just anonymised. But that country is where homosexuality is illegal as well, and the IPs knew this. But they were told that the birth wouldn't happen there, that and it would take place in Cyprus. But the agency advised that only one of them should go on the contract as a single man rather than a gay couple, so they would not encounter any issues. Should have been a red flag at that point. Then I'll just move my slide. Yeah, it was sticky. The embryo was created and transferred in northern Cyprus. The surrogate was from country Y, and she was not told that the IPs were in a relationship. She was after birth, but not prior to birth. And again, the IPs had to lie to the authorities to say that the surrogate and A, the biodad, were in a relationship. And as it turned out, excuse me, the baby was born in country W, and this is a country where LGBT surrogacy was not legal. And the surrogate and A, the biofather, was named on the birth certificate, and it's only then that the surrogate found out that they were in a relationship. Now, Tice deprecated their behaviour and added this case to a long line of cautionary tale cases that she has given judgment on. Now, the parental order was made, and this is because the welfare considerations were powerful, and that is the most important thing at the end of the day. But what she has done in this case, which is why it's important, is set out a checklist for IPs to follow and for practitioners to advise on. And crucially, this is what they need to understand before making their decision about certain jurisdictions. So I put them on the slide here. I'm not going to go through them, but it's paragraph 2 and paragraph 4 of the judgment. Now, actually, I had some clients the other day who were aware of this case and basically knew all the answers to all the questions, and I was like, you are the perfect clients. But of course, the IPs need to know about what they don't know. Essentially, they need to understand that. So a lot of these cases, the IPs are not getting the legal advice beforehand, and that's kind of where the issues start. But I'm going to skip through those. And I can share these if anybody wants them. The next case is X and W and another. So it's a 2025 case, another Mrs. Justice Tice case. This was a single male applicant with a surrogate from Kyrgyzstan. The embryo was transferred in northern Cyprus with the intention for the child to be born in the Czech Republic. UK was also given as an option. Sarah mentioned that. I'm also seeing that where people are saying, oh, the surrogate can come to the UK and give birth, and they can't be doing that. But the birth actually took place in Moldova, and where surrogacy is illegal, and the applicant said he had no choice but to agree. So this is they're told mid-pregnancy, surrogate can't give birth in this country, they have to go to this country, and there's very little they can do at that point. Again, the applicant was told to act as the surrogate's partner. And there was an issue in this case with the A1 or 1A, which is the consent form the surrogate has to sign to confirm that she consents to the making of the parental order. So it wasn't properly notarized, that was the issue. But Mrs. Justice Tice was able to look at the evidence in the round. So she accepted that the surrogate had given her consent by relying on a combination of other signed documents, the conversation between the guardian and the surrogate, and the communication between the surrogate and the applicant. So, so even though she hadn't signed or had notarized the actual consent form, the parental order was granted. As being in the child's lifelong welfare interests. And the last case about travelling surrogates is the REW Foreign Surrogacy Consent and Welfare, another 2025 decision by Mrs. Justice Tice. Another single male applicant and another surrogate from Kyrgyzstan. I hope I'm saying that right. The embryo transfer and birth were in northern Cyprus, and in this case, the applicant was prohibited from having direct contact with the surrogate. The issue in this case was that the consent had been given by the surrogate before the 6 weeks. In fact, it was 5 days after birth. And importantly as well, this was also given before the surrogate knew about the applicant's police investigations into an alleged sexual offence against his former wife. So it turns out that he was aware of this before embryo transfer, but he did not tell the clinic and the surrogate beforehand. Tice was not happy about that. He did say that he told his employer because he thought, you know, legally he had to, and didn't think that he had to tell the clinic. So what Tice was concerned about was the timing of the consent and whether or not she would still give her consent if she knew about the police investigation. But during the parental order application process, the local authority completed their child and family assessment, but they did close the case with no further action because they determined there was no safeguarding risk to the child. Various directions were made for the clinic and the clinic's lawyer to obtain a notarized consent from the surrogate and for the children's guardian to contact her. So the parental order reporter eventually was able to make contact with the surrogate, and she did reconfirm her consent, knowing at that point about the police investigation. So looking at the wide canvas of evidence and the fact that the parental order reporter met with her and she continued to consent, the court found that her consent was valid. And all the other Section 54A criteria were met and the parental order was made. Turning now to anonymous surrogates. So there's been 2 cases that have dealt with this. And the first was in February 25, REH Anonymous Surrogacy, heard by the president of the family division, Andrew McFarlane. This was a heterosexual married couple, both of Nigerian descent. They engaged with a fertility clinic in Nigeria, and the surrogate was anonymous to the intended parents. So she had her face covered throughout all of the appointments, which the IPs attended remotely. So they didn't know what she looked like, didn't know who she was. So the issue in this case was obviously her ability to consent, and they didn't know if she had a spouse, so whether or not they needed to consent as well. The IPs were directed to file a statement setting out the steps that they had taken to identify the surrogate, but all they were able to say after that was that they could only say that she was anonymous. This case took longer than normal. The parental order reporter prepared 4 reports, and it was only in the very last report did they actually recommend the making of the parental order. Prior to that, they were saying, no, we don't think you should make the parental order in this case. And it was because they can't get hold of the surrogate, don't know who she is, and there was no surrogacy agreement being produced. That was only produced in January this year, I believe, after that hearing. But it was only signed by the fertility nurse, the chief medical director and secretary of the clinic, but not the surrogate. So it was only had her initials on it. And the A101A consent form was also only signed by the clinic and not the surrogate. But the last parental order report did recommend the making of the parental order because they were then satisfied that the parties had entered into a surrogacy arrangement and it was in the child's best interest for the parental order to be made. And in relation to consent, they used Section 54(7), which said that the consent could be dispensed with on the basis that the surrogate could not be found. So the parental order was made, but the president did make a warning. So in paragraph 20, I'll read this out. A further cause for concern in the present case is the anonymity of the surrogate mother. Not only does anonymity prevent the court from being able to be satisfied that the mother knows of the application and consents to it, it also raises the level of suspicion that the arrangement may have been otherwise than it is said to be. Whilst Mr. and Mrs. H have explained their motivation for opting for an anonymous surrogacy, their decision has, in fact, caused them a great deal of difficulty in presenting the present application. Those who follow in their footsteps in the future would be well advised to avoid engaging with an anonymous surrogate. So this is not a good idea. But 1 month later, Mrs. Justice Tice was dealing with an anonymous surrogate, also a Nigerian case. So this was this is ex-foreign surrogacy consent, a heterosexual married couple who had twin girls in Nigeria via donor egg and the husband's sperm. They had no contact with the surrogate, and it was because that was organised through the Nigerian clinic. But in this case, the surrogate had signed an affidavit of consent at the High Court in Lagos, which was witnessed by a commissioner for oaths. Again, it's not the A101A form, but it was a form of consent. And luckily in this case, the parental order reporter was able to speak to the surrogate and ascertained that she had consented. There were still, however, three main issues with Section 54 criteria: the home, domicile, and consent. With home, when the application was made, the twins were being cared for by the wife in Nigeria with the husband in the UK. So there obviously the husband wasn't with the wife at the time. But we've had lots of cases that deal with the question of home, and the court took the same approach there in this case as they have in previous cases, and concluded that despite their physical separation, the children did have their home with both applicants. In relation to domicile, neither party were born in the UK, both born in Nigeria, but the husband claimed a domicile of choice in the UK, which was accepted on the factual evidence. And for the consent, the main issue, the judge found that the affidavits that were signed were clear in their terms that and provided the surrogate's consent. It was given more than 6 weeks after birth and was sworn at the High Court registry. And the surrogate had repeated her consent to the parental order reporter. So welfare was satisfied and the parental order was ordered. And then I've just set out the other cases that are dealing with the advanced age, domestic adoption, death of the applicant, and incapacity of the surrogate. Various warnings given in those cases as well. Very interesting.
So our final speaker this evening is Dr. Katherine Wade, who is Principal Investigator of the Children's Voices in Surrogacy Law Project. She is a senior lecturer in law at the University of Bristol Law School, and she is co-editor of the book Future Directions in Surrogacy Law, and a contributor to books including Family Law Reform Now and Ethical and Legal Debates in Irish Healthcare.
So I am speaking about insights from the Children's Voices in Surrogacy Law project, led by me, Kirsty, and also Zaina Mahmood. So this project is about obtaining children's views on surrogacy law. So we've heard about fantastic research being done about kind of children's welfare, their psychological kind of well-being. This project is very much focused on the law. And so it coincided with the Law Commission's consultation phases, where they were consulting with the public about what they thought about the law and potential proposals for reform. So we spoke to children about the law and law reform. So in phase 1 and phase 3, we spoke to children with direct experience of surrogacy. So in phase 1, we spoke to 25 children aged 8 to 17 with experience of surrogacy. So 7 were born through surrogacy, 17 were the children of surrogates, so their mother was acting as a surrogate, and 1 had a cousin through surrogacy. In phase 2, we spoke to 24 children aged 8 to 18 who had no direct experience of surrogacy, so children from schools. And then in phase 3, we spoke to 5 children who were born through US surrogacy living in the UK. And so this involved gestational surrogacy plus egg donation. They were aged 9 to 13. We recruited participants through the organisations, some of whom we've heard from today, so Surrogacy UK, Brilliant Beginnings, My Surrogacy Journey, COPS, and the Donor Conception Network. So in terms of data collection, we didn't go in there with an act. We didn't go in there talking about law. We devised a card game where we did games where they were voting and sorting things. And there was definition cards to help them understand. The topics were parenthood, contributions to surrogates, that should be, so gifts, money, and origin information. So they were the topics. We also collected data through artwork. So we had a creative corner And in phase 1 and phase 3, the prompt for the art was, what does surrogacy mean to me? And in phase 2, because they didn't have experience of surrogacy, the prompt was, what I learned about surrogacy today. So this is 54 children. It's giving an insight into surrogacy in the UK. So one of our first things that we did when they came in was we gave them Post-its and we said, what makes somebody a parent? So these are some of the words that came out in phase 1 and 2 and 3. So as you can see, some of the big themes that are coming out there is that what makes you a parent is care, love, support, responsibility. That came out in all of them. We had lots of funny answers too. We had drawings of cats and dogs as well. We did have biology, biologically related, coming up in phase 2. So just as a reminder, they're the ones without the experience of surrogacy in their lives. And we had IVF come up in phase 1. These children do have experience of surrogacy in their lives. So that's just an overview of how we kind of started off the conversation. And as you can see, there is a kind of intention-based model of parenthood, one that's based on love, care, and support coming out in the phases. We asked children, who do you think the parents should be when a child is born through surrogacy? We gave them 3 options. And as you can see, across all the phases, the majority said that that should be the intended parents. So you can see the majority said that in all of the phases. So what were the reasons that were given for that? Just have some quotes on the slides there. But generally, it was around the idea of intention, choice, autonomy for both sides. So the idea that, well, the intended parents started on this journey, decided to do this. They want to be parents. So that's the basis of their parenthood. And on the other hand as well, the surrogate chose to be a surrogate, not a parent. They also talked a lot about responsibility. Parents decided to embark on this. They're responsible for the child. So there was those kinds of ideas coming through. They're the ones that requested the child, who wanted to have the child. In phase 2, sometimes we saw a little bit more of a genetic kind of leaning. So genetics came into play a little bit more in phase 2. So as they're the ones who don't have experience of surrogacy. So here's a quote from a child in phase 2 who was talking about a differentiation between gestational and traditional surrogacy. So with the gestational surrogates, the intended parents that are the actual parents, and with the traditional one, that it actually could be both, because the child is genetically connected to the surrogate. So there wasn't a dismissal of IPs as parents there. But actually, we saw a few children with this idea of like multi-parent families. And just to note, we didn't tell them immediately about Law Commission reforms. We let them explore this idea themselves. But after they did these questions, we did tell them about parental orders, and we asked them, what do you think about that? And we had this, what we call the hairy judge, the visual there, to explain that to them. And they had lots of ideas about this, but lining up with what they said about who should be the parents, they thought that it was unnecessary or silly, and that really it should be, as you can see from the first quote here, this is the Law Commission idea of the intended parents being the parents at birth. But again, in phase 2, we saw a little bit of that differentiation again between gestational and traditional surrogacy. And here this child is saying that actually I get it a bit more towards having to go to court for traditional surrogacy. But overall, we did see that idea of we don't see why it's necessary. And somebody talked about why does there need to be a middleman. We also asked other questions about whether surrogates should be able to change their mind and genetic link, and they're all in reports online that you can go and look at as well. But just to move on to another one of the big questions, should surrogates be paid? So you can see, in contrast to the other slide that I have, lots of varying answers here. So there wasn't a clear-cut answer to this question. Children, struggled with this question as well. So lots of different answers, but just to give you some insights into some of the things that they said. Some children thought they should be paid. So because pregnancy is long and it's hard, and we've heard, ideas like this at the start as well around payment. So it's long and it's hard. Why should they not be the only ones not getting paid? But also some children expressed some concern around the idea of payment. Here's a quote from Scarlett, who was born through surrogacy. You don't want to feel as though you've been bought like a piece, like a toy or something, because you're not, you are a human being. We also had concern from children of surrogates around payments. So Jack here and Lucy both expressing negative emotion around the idea of their mother being paid for doing surrogacy. Jack was really pleased that he knew that his mum really enjoyed being a surrogate. And if money came into that, they might question that enjoyment and questioned the real reason why she was doing it. And Lucy agreed that it would negatively affect her if she knew that her mother was paid. They used some really kind of, forceful language there about being extremely worried. And in terms of origin information, we asked lots of questions about this, but just to give an insight, should children know the identity of their surrogate when they're born through surrogacy? And as you can see there, in phase 1 and phase 3, yes, the majority. Phase 2 are a little bit more variable. Again, they don't have experience of surrogacy. So when you're asking phase 1 and phase 3, you're asking them, should you know your surrogate? And all of these children did know their surrogate. And so that kind of gives you the background as to why their answers are like that. Generally, in this whole area of origin information, children thought that transparency, openness is important. That when children ask questions about how they were born, they should be given the answers to those questions. That secrets are bad, that betrayal is bad, and there's a lot of literature in the donor conception arena on that as well. But I will say they weren't particularly draconian about it. They didn't support a one-size-fits-all model, so they didn't think that there should be mandatory disclosure of origins. They were very much saying to us that it was family dependent, that it was dependent on the child, but they did say that children should be told young and that there should be no big reveal moment. That was the thing that kind of kept cropping up, that there should be no big reveal, that there should be no secrets. So they were, while they didn't want to set hard and fast rules, they were really in favor of openness in surrogacy. Contact was seen as really important as well. So here's an example of a quote from Jack saying that to start a journey with the surrogate and intended parents, it should be friendship based. And so they should have that relationship at the start and then it should continue on afterwards. So people talked here about the kind of contact that they liked, and we heard such lovely stories about the kind of meetings that go on between surrogates and their families. So they would meet, birthdays was a big thing. So the child's birthday, but also the surrogate's birthday. And one quote that really stood out for me was that a child saying, of course, you should still, keep in contact with the surrogate because she made you alive, which I thought was lovely. So this idea, she really had a status, she was really revered, a really important person in the family. Like we heard earlier, the idea of aunts and cousins came in. So the kind of contact that went on was, dinners, calls on the birthdays, walking dogs, FaceTiming. So we heard about that. They said it was nice. They really valued it. But again, just to kind of go back to that idea of there's no one size fits all model, it's really important to talk about it beforehand and set out what everybody is comfortable with. It's not essential to have contact. It's not essential to have the same level of contact for everybody, but these children really, really value the contact that they had with their surrogate and that the children of surrogates had with the other family. In terms then of we got other insights, not just about the law, around how these children navigate surrogacy in their everyday lives. And really was a very, very positive insight into surrogacy. Children were happy and proud to be born through surrogacy. They told their friends, some of them spoke about it in assembly. This child says that she's really thankful for the kindness of her surrogate. And then the children of surrogates were also really proud. So this child, Jack, said, I'm really proud of my mum for being a surrogate and for kind of helping people in this way. I've never hidden it. And Camille said it was an amazing thing and you should be really proud of it. Your parents are your parents and I don't know what else to say. I just thought it'd be lovely to put up some of the artwork and give you just a few seconds to look at some of these. We are publishing on the artwork at the moment, so I have an article going through on this. So I think you can see the theme that comes through these pieces of artwork that I have collected and put together as being love. So you can see here, love is depicted in lots of different ways. We saw that there was love, multi-directional forms of love. So this is a picture of two IPs. We also saw love between surrogates and the IPs, the child the surrogate has and the surrogate herself. So there's all different types of love going on. Here's an inclusive message. Love is love, surrounded by fireworks. We have kind of the stork delivering this present in the heart, the symbol of love. So that is just a selection of artwork. And here is a second selection of artwork that I put together based on a recurring theme that you can see, which is obviously holding hands. And the theme that we found in the art from this kind of image was connections, that surrogacy forms really special connections, some connections I didn't even, know about, the connections that are formed between children of surrogates who meet at events and they share their experiences together. And this is a lovely piece of artwork. In the middle is the surrogate, and she is spreading joy to the parents. And inclusive models of surrogacy being depicted there as well. All of the artwork and the reports are available to view on our website. So I've included a link and also a QR code there.
So first one is for Sarah Jones. So someone who's anonymous said, you argue that surrogates should not be considered the legal mother and should not have a veto. So why do you think surrogates should have the right to withhold or withdraw consent at any stage until the parental order is granted? Do you think that surrogate consent should be capable of being withdrawn for any reason whatsoever, or just for specific reasons? What about the rights of the genetic parents and the right of the child to be the legal child of its genetic parents? So not much for you to unpack there.
Yeah. A little answer will be, well, personally, I don't think anybody has the right to veto a child's contact with important people in their lives, like whether that be parents or, extended family and things like that. So that's point one, personally. Personally, I think that I, as somebody that can give informed consent, can also make the decision that I want to give that consent before birth. The Law Commission didn't go that way. They had a very much more measured response in keeping this sort of safeguard, just in case a surrogate wanted to change their mind. And as we've seen in the past, that's a really minimal amount of surrogacy cases that end with a surrogate wanting to change their mind. However, I fully appreciate that there should be a safeguard there for those people, but I think the important thing about the legal reform is that then it changes and then it goes to family court for family court to decide what's the best interest of the child. And I think that's what's important. So nobody really has the right to a child. So if anybody disputes, it goes to family court. Whereas at the moment now, a parental order cannot be granted if that surrogate doesn't consent. Yes, there may be other pathways that intended parents can go down to get legal parenthood, that where a family court can decide and can overrule that consent, but the parental order pathway doesn't allow that. So it's that absolute veto that I don't think should be allowed. I don't think anybody should be able to make decisions about another human being that might or might not be in the best interest of that child. So I think it should, in the case of dispute, should always go through family court.
Does anybody else want to come in on that one? Or in the interest of time, we will move on. Okay, so Lottie Park Morton has asked, oh, sorry, Kim, I just saw your hand. Did you want to come in? Sorry, you're on mute. Kim, you're on mute. Oh, you've muted yourself again. Sorry, you unmuted and then did it again.
Oh, sorry. Is that all right now?
Yes.
Yeah, no, I disagree there. I can't see. I think the intended parents would live in absolute fear if they thought any time that a surrogate has the right to change her mind. It so rarely happens. In 3 decades, I've not known any surrogate change her mind. And I think the IPs would live in fear if she has that right to it. I think if there's an absolute reason that she finds out something that was not disclosed that would prevent her feeling that this is in the child's best interest to go to them, then definitely a family court must decide. But I don't think a surrogate has the right to change her mind just for any, I don't know, whimsical reason, really. If you're a surrogate, you have all that screening, you know exactly what you're letting yourself in for, and you shouldn't change your mind. You're messing around with people's lives.
I think I'm going to...
can I let Natalie come in and then we'll come back to you, Sarah, because Natalie's been chomping at the bit.
Just to say, I've dealt with 2 cases where the surrogate has changed her mind, UK based, traditional surrogacy, and they are decided in the family court. The surrogate does have the right to change her mind for whatever reason in the current law as it is at the moment, but that is not the end of the matter. It's the end of the parental order, but it's not the end of the matter for the child or the intended parents. So the intended parents in the UK system do live with that fear that a surrogate could change her mind, because she does have that right to do so. But there is the family court who will then decide what's in the children's best interests.
Sarah.
I was just going to add really quickly that the cases that I know of, the handful of cases that I know of, hasn't been because the surrogate wanted to retain custody. There's been some dispute between the parents and the surrogate, and I really oppose anybody having the right to stop a parent seeing the child for a dispute in that way. I think that's what I wanted to say.
Yeah, there's been some people who've been a bit dog in the manger. Right, I am now going to move on to Lottie's question. So given that Section 54 cases are only likely to be reported where there is an issue or contentious elements, how do you think we can keep the momentum for reform and media publicity focused on the positive lived experience as opposed to the minority of cases of potentially poor and unethical practice? Well, you brought these cases up, Natalie, so we'll go to you first and then perhaps to Kirsty.
Well, I think events like this, where we all get together and we're in a public forum and we're able to debate our issues, and if we disagree with each other, we can say that. It's a safe space and everyone's entitled to their opinion. But the media seems to latch on to these big cases, and it is a shame actually that the straightforward cases don't get reported, and perhaps they should. But it's the sensational ones. It's the one where there's parents that are in their 60s that gets that media attention, and they are a gift to the anti-surrogacy.
Oh, Natalie seems to have frozen. Paul, you want to come in?
Natalie's back. So I think as a community we should.
Sorry, Natalie, you froze quite. You froze. So.
Oh, I'm so sorry. God, what was I saying? I just think that we should all be able to raise our voices and give the surrogates an opportunity to speak rather than have people speak for them.
Great. Paul?
The only thing I'd add to that is I don't think we should shy away from these cases. These cases actually should support the argument for reform. And I think that's what I mean about the law reforms being misinterpreted as liberalisation. The whole point is that they should hopefully encourage more people not to have these kind of what seem to me crazy arrangements abroad where they're not meeting each other properly, where they can't know safeguards are in place, because the whole point is the UK becomes the ethical place to do surrogacy because you have such good proper regulation checks before conception. So actually I think sometimes for these issues, if we shy away from the reality of the worst experiences, it doesn't help anyone. I believe in honesty. These things do happen. They do happen in a very small minority of cases, and we should embrace talking about them as well.
Does anybody else want to come in, or I will move on? Nope. Okay, so a question from Sarah Patterson, who says, how do you truly differentiate between a gestational surrogate and the recipient of a donated embryo? Is it simply intent? I found the language used to justify the parents of a child in both scenarios quite conflicting. With gestational surrogacy, the surrogate's role as mother is disputed as the child isn't genetically related to her. However, with embryo donation, the mother role of the recipient is justified by carrying the child as an important part of the process. She's not asked if anyone in particular. Kirsty, I'm going to go to you.
I thought you probably would. I do think intent is important in that, because somebody who is receiving a donated embryo, a woman who is receiving a donated embryo during IVF procedures, wants to be that child's mother. And that's the reason they received a donated embryo in the first place. Whereas an embryo that is transferred in gestational surrogacy is not a donated embryo, it's the embryo that the intended parents intended to parent. And they wanted to be the parents of that embryo, and they unfortunately can't do it themselves. And so the surrogate intends to help them become the parents that they wanted to be, and they provide their genetic material to her in that sense, to allow her to help them. And so I do think, intent does matter, but the whole reason for doing it in the first place is totally different.
Great. Okay. Paul.
Sorry to jump in again, but
That's right.
on that same theme of what I was saying earlier about just being honest about things, what I've found in the discussion about these kinds of things is everyone tries to shoehorn different families into the conventional family. So, the surrogate is the mother, this person is the father. The reality is just the reality, which is, I believe very firmly that a parent is the person who is waking up night after night after night, looking after a child. I'm not genetically related to my son, and it hasn't, I can't imagine, and my new son, who's due to be born at the end of August, will be genetically related to me, and I can't imagine for a second that I would love that child anymore. I think it's about the showing up day after day after day. But equally, if my son grows up and wants to call Rachel his birth mother, he should go for it. And if he wants to call the egg donor his biological mother, then good for him as well. And that I'm not scared by those terms. That's the reality of his existence. And I think some people assume that everyone who has a child through surrogacy wants to erase the roles of these women who have helped you. And actually, we believe the total opposite in kind of celebrating those roles, because that's why we have our family. And we can all just kind of be a bit more honest about who everyone is. It doesn't have to fit into that traditional kind of, there's one person who is the mother, there's one person who's the father.
Great. Thanks for that. Okay, so the next question is from Emma Sowerby, who says, do all the speakers agree with the proposal to keep the requirement for at least one intended parent to be the biological parent of the child? I know this is something we have talked about quite a bit, so I'm going to go to Kirsty and then to Kim.
I don't. But I do think there's it shouldn't be a free for all necessarily. I don't think you should just be able to go out and pluck embryos off a shelf or anything like that. But I do think I've come across some situations before where people have embarked on a project via IVF and created their own embryos and things like that. Found out that IVF doesn't work. They've used some of their embryos, have then come to surrogacy, have used some of their embryos, and then they run out of embryos, by which time they're unable to create any embryos. So I certainly spoke to one woman who'd had cancer in the meantime and had to have a full hysterectomy. That's what led her to surrogacy, and then she also had no eggs left to create embryos with. So and had separated from her partner, hence no sperm. So I think you could see it as a part of an ongoing project. So I think where there is, I think the Law Commission's termed it originally like medical need, but it's a broader concept than that. But where there is a circumstance that would justify it, I don't think that not being biologically related to the child you intend to parent is problematic.
So Kim, and then Sarah, then Natalie.
I think that the best interest of the child is to be at least have some genetic connection to one of its parents. Otherwise, there's absolutely total confusion of who am I? That's my opinion.
Okay, Sarah Jones.
Yep. So my opinion is in some cases, because I can see the risks of double donation with traditional surrogacy, for example. So where it's via at-home insemination, you would have a real struggle to prove that that was a surrogacy case, because it might just have been somebody that had gotten pregnant. So I think if it's through a clinic, then I don't necessarily have an issue with it. But I think there is a great risk when you're talking about traditional surrogacy and double embryo donation. Double gamete donation.
And Natalie.
So I think it disproportionately disadvantages women, single women, because if they need surrogacy, they're unlikely to be able to use their own eggs, so they're not going to be able to get the parental order, whereas single men can use their own sperm. They have that biological connection, egg donor, surrogate. It's easier. but also it doesn't stop people wanting to still have their children. And as Kirsty says, I mean, I've got a case at the moment where it was starting through wanting to carry and then using egg donor, and then in the end she used surrogacy. It was in Nigeria. She now has to adopt, so it's a longer process. It's more problematic for the child because it's longer without having that legal relationship. And if we're talking about intention, these are people who intend to parent these children. When you adopt, you're not biologically related to your adopted children, and that's fine. So, but what we want is to be able to have those checks and balances before the conception, ideally, but we don't have that at the moment.
And Paul, and then we better move on to the next one. Paul, you're on mute still.
Just to raise one specific issue that can happen because of the double donation thing, when Rachel was pregnant with Solly, my son, who I'm not genetically related to, had something happen to my husband, if he would have died during the pregnancy, I would have been left in a situation where Rachel would have been left in a situation where potentially I couldn't become the legal parent of my child. She was left with legal responsibility that she didn't want. So I agree with what Sarah was saying, that at least on a case-by-case basis with those kind of things in mind. I tried not to think about it at all, but it was there somewhere in the back of my mind. That is an awful thing that could happen. So it's just something to add to the discussion.
Yeah, no, that's a really important point actually, because unfortunately, there can be these tragedies. Right, so I'm going to now go to a question from Pauline Everett. So her question is for you, Kim, and she says, what were your motives in being a straight genetic surrogate and then changing to a host gestational surrogate? And why did you say in your second book that you would not do genetic surrogacy again?
I had no choice. Can you hear me? Yeah. I had no choice in 1985 when surrogacy was, starting. There was no choice, and I didn't know any better. So the only way that I could participate in the American program was to be the child to be genetically linked to me. And the fact that I didn't know the couple either, and it was anonymous, is totally, it disgusts me now, to be quite honest. But at the end of the day, that's something I have to live with. So when somebody through Cots that I'd met, her surrogate wouldn't travel up to London. It was too far for her. And I found myself offering to be a surrogate for her. And I thought this time it could be very different because the establishment's involved. So for me, very important not to have a genetic link. So when I handed the twins they were born one each to each one of them. I felt emotionally I'm giving the babies back to their parents. And it was totally much a different feeling for me altogether. I still love them. I'm still in touch with them. They're in their 30s now. And I have a special relationship with them. But it's not my responsibility because they're genetically with their parents. But with baby Cotton, she's 40 years old. She's somewhere out in the world. I don't know anything about her. And whether she ever finds me or not, I don't know. It could be a very difficult situation moving forwards if she does find me.
Yeah, thank you very much, Kim. I'm going to go into Emma Xiao has asked a number of questions. I'm struggling to think which one to pick. So one of hers is, according to statistics worldwide, commercialized surrogacy often correlate to decreased protection of surrogates. Why would that be? And what are the upsides for altruistic surrogacy in contrast to commercialized surrogacy? And she said, that's a question for you, Sarah. And then she said some very nice things about you, which I won't read out to spare your blushes. But if you could go first on that one, thanks.
Yeah, I think, well, ultimately, if there's money to be made in it, there's somebody to be coerced, and there's vulnerable people to take advantage of. I think that's pretty much about anything that's commercialized. So I think that's why surrogate care goes down in countries where commercialization happens, essentially. And I think what was the second part of the question? Sorry, Sarah.
Sorry, I've now just put it in my answered folder, so I'll be a moment.
Sorry.
Don't worry, it's my very, very poor memory. Hang on. There we go. Oh, is it where is it? There we go. So the second bit, why would that be? What are the upsides for altruistic surrogacy in contrast to commercial surrogacy?
So the upsides for altruistic or non-commercial surrogacy is that there's no financial coercion there. And you then get people who want to be surrogates volunteering for surrogates, not people that need to be surrogates for, financial reasons. And I think that's a really big distinction, because you want women that are choosing to do this, not needing to do this. So I think that really is the key differential for me. Yeah.
Natalie?
So I don't think every commercial jurisdiction is going to have unethical practices and that surrogates are not looked after. We deal with lots of pathways through the US, and they are paid, and other jurisdictions like Mexico, and they are looked after. So I don't think it's as straightforward as saying commercial surrogacy bad, altruistic surrogacy good, because we will have issues in this jurisdiction where surrogates, are falling out with their IPs, they don't feel looked after, it doesn't matter, and they're doing it altruistically. But yeah, I think there are nuances. I also think there are bad actors. I just don't think it's as black and white as that. I think it's definitely a grey or a multicolour, and we should look at things individually. And if we're wanting to change the law here to make it so that it is regulated, and we are having someone like the HFEA overseeing it with the RSOs and the surrogates care, and all of that welfare of the child is done prior to conception, I think we all agree that that's all a good thing. We don't have that at the moment. It's all done post-birth. So our system isn't perfect. But and also, just to add my two penneth in as well, surrogates do take all the risk and they do all the work, the actual reproductive labor. We, as like surrogacy professionals, we get paid, and no one bats an eye about that. So should there be a conversation about surrogates getting paid? Now, obviously, I know what the views of the panel, and views of children as well, who probably don't like the idea of their parents getting paid. But perhaps that's just an icky feeling we have about money, rather than actually paying a surrogate what she's worth.